thing about Dolly Parton I can't say on there.
Okay, you better not. Oh dear. Wait, it's okay. It's okay. It's okay. So you have to thank you for coming. Good morning. Good morning. Good morning.
Nice songs.
Yeah, very, very nice song. That's true. That's true. Agreed. Okay. Eric Delalifo, Esquire, is a member of the NC's legal team. Eric, good morning to you.
Good morning. How are you?
I'm good, sir. I hope you're also
well.
Good to see you. Yeah, of course.
Do you like it?
Yeah, I like that. I like her music. You know?
Okay.
Oh man, we're gonna have an awesome time this morning.
One of these Fridays, let's have a study of the party as a topic and not talk politics.
It will be something. Okay, we'll also be joined by Pargrave Boachidankwa. He's already in the house. He's just joined us shortly. He's the government spokesperson on governance and security for our discussion this morning. Gentlemen, thank you so much for joining us. On that very Dolly Parton note, it's okay. I guess we can move on to the matters on the table.
Be very careful when I'm telling you
My focus was on the quote of many colors, but clearly the author of the song is bringing something else.
You can't speak your mind. And they're no person to be
All right.
Laughter is good for this. At least to bring down the pressure on the politics in this town.
All right. Okay. I guess we can just go straight to the matters already this morning. So this week in the ambulance trial. All right. Okay. So the High Court in Accra this week, in fact, just yesterday, took a decision on the applications that were filed in the matter of mistrial. All the 4 applications that were made were dismissed by the judge. However, she also indicated that the tape in question that had been brought had been admitted into evidence, and also that she would advise that the Attorney General recuses himself from this case. It was an advice. The AG says it's an advice. Advice means you can either take it or not. His decision is not to take it, and that he will see through the case as he has already begun. Eric, let me start with you. What did you make of the decision of the court? And thankfully, both of you are lawyers, so I'm in good company in how we, navigate this. And then also, what's the other element relative to the evidence that has been admitted means for how we see through this matter?
Okay, thank you very much, and good morning to listeners also. They've been waiting for us for a while, I think. And I do not agree entirely with the decision of the court.
Okay.
I've not read the ruling very well, but I was in court, so I listened to the judge as she read the ruling. I think that she had a golden opportunity to rule favorably for the applicants or the defendants in this matter, because this is a gray area of the law in our jurisdiction. And I was one of the people who had pushed very strongly for an application for mistrial to be filed. I know too well that I have done.
Oh, you actually filed for a mistrial?
No. I'm saying that I'm in the school of thought. I have argued at various forums, pushing that we should file an application. The defendant should file an application for mistrial, because the misconduct of the Attorney General is egregious. And I think that we should. I knew all along, and we know, all of us know lawyers, and I have done criminal practice all these years. I have my own private legal aid scheme called Help Law Ghana, and I've been providing free legal service. So I know how the criminal. So I know that this issue of mistrial is not part of our practice. It's not in our jurisprudence actually, but but it's a common law concept. It's not a codified principle in the law that is written anywhere. It's a common law, and we are a common law country. And most of these concepts are developed from cases that go to court. And so when the case goes to court, the judge looks at the circumstances and think that in order to do substantial justice, then I have to declare this a mistrial because there's misconduct and all of this. So once it's a common law concept, whether we have practiced it here
Or
before or not, it should be possible to file an application and make an argument strongly for why the court must uphold that principle. And so I think that it was appropriate that they filed the application. However, the judge ruled otherwise because the judge was adhering strictly to precedent, and because there are no precedents in this country, so she found solace in that and said, well, yeah, it's not part of our practice. I have a problem though, because you see, I was in court the day the applications were supposed to have been moved. And that day was a day the defendants would have presented their case to the judge, and the judge didn't allow applications to be moved as we do in court, because in this type of applications, apart from the injunction application, where the parties also write arguments, what we call the statement of case, and they come out with their arguments and all the authorities and all of that. Applications, ordinary applications, are only supported by affidavit. Affidavits are just facts that are sworn to. So there's not supposed to be an argument in affidavit. So you just file affidavit. These are facts. This happened. This happened, and then you swear to it, and then you attach your evidence. So it is when you are moving the application that you do the argument.
Yeah.
Yeah. So when you mention the paragraph, then you support it with your argument. And if you have authorities, then you... But they were not given the chance to move the application.
They said everything should be written.
Yes. No, everything was written and filed already. You see, everything was written. And we went to court on Tuesday. Tuesday was the day they knew they were going to move their applications. So like I'm saying, the lawyers, if they would have authorities and arguments, it would just be in their notes, not notes that were prepared to be handed to the court.
Yes.
Because they have provided their motion or their application paper supported by the affidavits and whatever evidence they had. So they knew they were going to go and make the argument. So if in court that day, what the judge told them was that she was going to hear only, there was an objection, preliminary objections to the affidavit in opposition that was filed by the state. And they filed only one affidavit, to the 4 applications, they filed only one affidavit in opposition. And they said they were okay, they were going to be able to attack all of them, but that one is sufficient for them. But that particular one also was objected to by lawyer Thaddeus Starr. And that was the only application, let me just call it application, the objections. That was the only thing the judge heard in open court. The rest of all the applications, the 4 or 5 applications that were filed, she said she was not going to listen to them in open court. She can read them. And it's not like she even gave them the chance to come and move the applications even in chamber for them to make the argument. She only said that everything that they provided is there. It's just going to rely on their documents. Then along the line, when there were a few discussions, then she said if anybody has any authority to give, any information to give, she's prepared to take it in the next hour, in the next 30 minutes or so. And then she's going to sit down for 2 days and work on the judgment. Clearly, between Tuesday and Thursday, and basically Thursday was out, so that Tuesday, and then Wednesday, the lawyers will not be able to put up all their arguments and prepare their documents and send to the court. They were frustrated, as far as I could see. They were very frustrated because they knew they were going to move an application, and then they came to court. So you see, what would have happened is that if they had moved the application, they would have cited instances and precedents from various countries and established to the court why it is important for the court to adhere to some of those principles. And then the court could even ask questions. The judge could ask questions. They could go back and forth to explain and all of that. But she denied them all the opportunity, and then she came back and dismissed all the applications. So I'm not very sure that that is very good for our country. I just wish that the defendants will appeal to Court of Appeal, and if they deny them, they should appeal to Supreme Court. I wish they would do that. I don't know. I'm not part of the legal team for any of them, so I just wish that they would do that. But the judge also made a pronouncement pertaining to the Attorney General, and she said that she would strongly advise that she stayed away.
He
from
stayed
the
away.
case. Yes, she was strongly. In fact, she could have said, I'm making an order that you stay away. But the reason she couldn't do that was that and even when she said she strongly advised, she said that did not mean that she's making any value judgment on the evidence that was provided and blah, blah, blah. She said all that accompanying the evidence. So if she was going to make an order, it means that she was going to determine some of those applications, determine the applications in favor of the applicants before she can make an order. So and once she doesn't want to, or she didn't want to determine those applications on their merit, but rather dismiss them on technical grounds, she can only advise. She can only advise, because if you are ordering, it means that you have found something completely wrong, and it means that then you are ruling in favor of the applications, and then you can make an order. But once she dismissed those applications on technical grounds, not on their merit, she can only advise the Attorney General. So she's saying that, yeah, although I didn't find that this, because I didn't actually interrogate this, I listened to the tape, and in my opinion, I strongly advise that you stay away. She couldn't have said it any better than that in the circumstances, that she didn't really interrogate the applications and the evidence that was provided. So to most of us, it's as good as an order to the Attorney General, because if a court advises you that stay away from the case, and not just say, oh, advise, strongly advise, I think that an obedient and an Attorney General who is not arrogant will take that advice. And he has a team.
But Eric,
yes,
advice as it presupposes,
yes,
is one that you can opt to take,
yes,
or not.
Yes,
but not taking does not amount to arrogance, does it?
I've just laid the foundation why I'm coming to that conclusion. I've laid the foundation. I've said that, look, she saw something wrong with the conduct of the Attorney General.
That's your inference.
Yes, and how else would she tell the person to stay away? But I'm saying she couldn't.
No, his inference in terms of seeing something wrong.
Well,
but she did see something wrong.
Yeah, if she didn't, why would you tell an Attorney General who is prosecuting a case to stay away from the case? Advise it. And I'm saying that she chose the term advice because she didn't make determination of the application. Because if you would order, an order can only be based on finding that something has gone wrong.
Okay.
And once she failed, or she refused to interrogate the applications that were provided, because those applications were not, she only dismissed all of the applications, saying that she didn't have jurisdictions, this is not known in our laws, and blah, blah, blah. And then she dismissed all of them, you see. But at the back of her mind, she realized that there was something wrong with the conduct of the Attorney General. In fact, then she referred to only one of them and saying that the Attorney General asked the witness to go and procure a medical report. That would be a fraudulent procurement, because then if the person is not sick, and you go to a judge, a physician, to tell the person that, oh, I need a medical report to send to court, then first of all, you would procure it fraudulently from the hospital or clinic or wherever, and then you go to court also and present it, another fraud over there, because perjury, you will be lying to the court. So that for the Attorney General to advise a witness to do that. And she was very strong also on the point that Attorney General spoke to a witness or a party in the case about the evidence that is going on in court. And she has discomfort about that. She said it. She used the word discomfort, one other word. She was really not happy, but I'm sure she couldn't have gone too hard on the Attorney General. Attorney General is the first gentleman of the bar. And so clearly, the judge, and I understand also why, but this is just by the, I just understand the judge was also part of it. She was a principal state attorney in Kumasi not too long ago. And so she was, well, I'm only giving facts. I'm saying that, look, my former boss, I will always defer to my former boss. You understand? And so, yeah, clearly, apart from the fact that she didn't want to go too hard on the attorney general, also, yeah, former boss. Now, she's a judge. So, judges are our bosses in a way, because we go to them and they make decisions. So, yeah, so the language, she tried to make it polite, look nice. But clearly, if this is the very first time I have ever heard something like this, in Ghana, where a judge is telling the chief prosecutor in a matter that you better stay away, I would strongly advise you that you stay away. If the person did not do anything wrong, and again, she added that for the integrity of the court, for the confidence of the people to remain in the court, she would advise her, she stays away. The attorney just says, well, because it's an advice, like you said, everybody says advice, so that's why when he says he would not take it, we can't fault him because he's giving us an advice. So I'm not saying that he's compelled to. No, that's not what I'm saying. I'm only saying that the judge couldn't have put it in a different way, but Attorney General, a very smart guy, should have seen clearly that what the judge is telling me is because she didn't determine these applications on their merit. If she had done so and found that there was something wrong, then probably the advice it's giving would have been an order. So if he's saying advice, it should just occur to him that what the judge is saying is that there was something really very wrong and you better stay away, so that in the end of it, because look, if this case goes in a favor of the state, all of us are going to say there's injustice. I would say it clearly, because yes, and that's what Ghanaians should say, because we have seen the misconduct. We have seen how the Attorney General tried to bamboozle a party in the case, and we shall say it is. You see, this country, one thing I've noticed is that, and especially,
Are you not prejudicing the case?
it doesn't matter. They have
It does.
Yeah, no. You see, the Attorney General has already done
Eric, it
so.
does. You are a lawyer by
Yeah,
training.
you
You
see,
know what prejudice.
No.
Is
Yeah, no.
the
Let me just finish.
Is the evidence that has been brought?
Yes.
Is it an exhibit in the original case?
Yes, that is another thing that I need to be very clear about.
Yes.
The evidence of the tape, you see, and I was saying that
That is why
it
she
is not
had it
evidence.
outside the case.
The evidence is not admitted into the main case. That's not my understanding.
Yes.
It was accepted for the purposes of the applications that were
Yes.
presented.
Okay.
But people were making it look like that evidence, the tape recording was put in evidence in the main case. I'm not too sure about that. I don't know when that was done.
It
was
only came in because
Of the applications that have been made.
Unless if in any of the applications it was stated also that we wish to present this tape to be admitted as evidence into the main case. If it's in one of the applications like that, then
That
the
is
judge is saying
when the
yes.
Japa made the accusation he made.
Yeah.
His lawyer should have told the judge, we want to present evidence
Yeah.
of what my client has
He's
just
speaking
said.
to. Okay.
Well,
Didn't.
I don't know if the rules at that point allow that.
We do not also know whether the application that has been filed by lawyer for Mr. Jakpa at the Supreme Court will have any element of this therein.
Yeah, that's what I'm. That's
What
the
I'm
point.
talking about, the original
That's the
case.
point.
Yes.
I mean. But you see, the original. You see, Mr. Jakpa made the allegation the first time when he was being cross-examined.
Yeah.
Yes.
You see, Mr. Jakpa would have already presented all his evidence in chief through a witness statement and everything. And our understanding is that he didn't say anything about this. He didn't add any recording or anything.
just said
It was
he has
only
evidence.
during
Yes.
it was only during cross-examination
That it
that
came
this
up.
issue came up. So it's a new issue altogether, which is not in evidence. Yeah, I never agreed with the people who were saying that the Attorney General could have risen and objected, not objected, and denied the allegations at that time and all of that. I'm not too sure that at that point he could have done that, or he should actually do that. Yeah, but the point I am making is that I think that, you see, we shouldn't, and the press, the media, and all those who are listening to us, they shouldn't say that because this is just a mere advice. The Attorney General should. We can't, because that's the way the judge couched it, so we can't do much. But our understanding should be that the judge found something grievously wrong with the conduct of the Attorney General and things that the Attorney General shouldn't be in the case. But for some technical reasons, she couldn't make an order. And so, if for the very first time, the one who is the chief prosecutor of a case, and the court is telling that person that in order for the integrity of the court to be maintained, in order for people to believe that when they have controversies, they can only deal with the controversies in the court, but nowhere else, he should stay away from the case.
Okay.
I believe that if he really wants justice, and then he really wants us to trust the system, the justice system, then he should stay away from the case. If he refuses, you see, you people always force us. I'm saying that if he refuses, and the same person that is strongly advised to stay away, go on to do the case. And I'm saying that at the end of it all, to be injustice. You say, hey, why are you lawyers saying it to be injustice? But if you are presenting the basis, they're laying all the basis for that. This man was trying to tamper with the witness, push the witness, come and say it. We don't know what else. In fact, this would have led to a clear mistrial in U.S. Very clear mistrial. In fact, yesterday I was even looking at a case where a mistrial was declared as a result of the conduct of a defense attorney. Defense attorney, you are defending, because the court had agreed with him that a certain evidence should not come in. You shouldn't ask questions during cross-examination. And then he asked. And then they declared mistrial. So that one clear, because that's a defense. So if they declare mistrial, it is in his favor. And they even declared mistrial. The only thing is, I will see in a mistrial, then it means that without prejudice, the case can still be brought. But it doesn't even happen. In U.S., you see, U.S., the system is so developed that the liberty of the citizen is paramount.
It's sacrosanct.
So you hardly see the state appealing a case that they lose. Because you see, the state has a long arm to go after anybody you want to go. You can always find something. You have all the resources that you can marshal against citizens. And so the system doesn't allow the state to do that so much. So once a jury decides that the person is acquitted, hardly would you hear that the state is appealing, because then it means that you are harassing. So most of the appeals in the Court of Appeal and Supreme Court are from the defense side. They are from the defense side, not from the state.
Okay.
So that, but here they will push you. They will even force you to do your own case in court. The first, when the Attorney General was denying, when this allegation came out the first time, the first statement they issued, they said no, he never contacted this man, he never spoke with this man, blah blah blah. And then later on, when there was an information that made him to see that I was probably there's evidence against me, then they said, I spoke to him, or he spoke to him when he didn't have a lawyer. You see, and then a lot of people, they were running with that yes, he spoke to him only at the time that he didn't have a lawyer, because he knew clearly that it is against the ethic rules to speak to a party in a case that has a lawyer. So he didn't have a lawyer. But you see, if he didn't even have a lawyer, though it was even shown clearly that at the time, on the day that he spoke to him, the man had a lawyer.
Okay.
But even if he didn't have a lawyer, you see, what we should be looking at is that, you see, at all times, Mr. Jakpa had shown clearly that he wanted to be represented by a lawyer. It doesn't mean that in the course of the trial, at certain points, he may lose the services of the lawyers that were representing him at that time. It means that he will just have to go and get another lawyer. So if in a very short window, brief period, he didn't have a lawyer, you knew that the man wanted a lawyer. In a developed jurisdictions, the court and all the prosecutors will have to help him to try and get a lawyer before he even continues the case.
With the case, okay.
But in this country, they will force you. You are wasting our time. You are wasting our time. Do your own case. And that's what they did it to Chachu Chikata. We all know. The day Chachu Chikata was jailed, his lawyer was not in court. He wrote to the court and said he was not going to. They say he himself is a lawyer. He should represent himself. And that's what they did to this man also. And so I don't think that we are helping our justice system. And when now we realize that it is the Attorney General who is supposed to defend the system better than all of us, is one of the people who is trying to bastardize the system and use ways and means to get his way. It's very unfortunate.
Okay. Eric, thank you.
That's my information.
Palgrave, what do you make of the decision of the court from yesterday on this applications for mistrial and the advice of the High Court judge for the AG to recuse himself from this case?
Good morning,
Morning.
Francis.
Morning.
And good morning to Eric and to lawyer Jantua.
Good morning.
And to your viewing public. Today is Green Ghana Day. I didn't find that in any of your conversations this morning.
We've had quite a bit on it already this morning. That's why.
That's fine. Okay, that's good.
Oh,
Francis,
that's why you are in the green glass and green
no,
kaftan. Okay.
Green is my favorite.
You
color.
are green all through. Okay.
Green is my favorite color.
All right.
When I saw him, I thought he was working in the ward or something, or
Eric
like a new medical officer in the house.
Eric is interesting. Francis, I'm concerned that we have had a former Deputy Minister for Finance and also now minority leader in Parliament. I'd followed the conversations and the case, and I'm concerned that no one is angry about the issues that have happened, especially with how he asked the Bank of Ghana to issue letters of credit, how the vehicles had not even come in at the time, how when the vehicles came in, about 30 of them, the former Minister for Health, Dr. Alex Tebefia, together with the ambulance services, went to inspect the vehicles and stated that it wasn't to the specification of an ambulance, and what the MPP calls it trotro.
And that's why it was parked for almost how many years?
Well,
and was not furnished for use?
I'm deeply concerned because you see, Francis, as we are growing and trying to bring a lot more development into the country, it's important that we become responsible. Both sides become extremely.
But that is a matter that is being dealt with in court,
Exactly.
isn't it? And that's why for many people, we have had to wait to see what the outcome of the decision would be.
Exactly. So we become very responsible because responsible governance is what is key. You cannot pick people's tax and manage it in the manner in which you have.
There is a reason I am trying to stop you with this, because the court will determine if anything untoward has been done in this matter. That's in the facts of the case.
Okay. Okay.
So I would rather we do not pass judgment
No,
on a matter that is yet to be fully determined in court.
Yes. But I'm raising the issues that it concerns me.
Okay.
Okay. It concerns me that something of this nature has happened. Well, I'm glad it's in court and
Allegedly.
allegedly.
Until the court determined that these are matters of fact. Okay.
Of course. Allegedly. But I'm glad that the matter is in court.
Okay.
And that is being investigated and it's being trialed. Yesterday's was a good day in court. The respected judge gave her trial.
Her judgment.
Her judgment. And
On the applications.
on the applications that had come.
Yes.
I mean, before her. I think she's right with what she's brought forward. I mean, obviously, it's based on her own understanding of the issues. And it goes in case that it will be made reference to in the future of something of this nature that has happened, because we are binded and guided by the regulations and the guidelines of law and the advice that has been given to the Attorney General. When the judge says that you should recuse yourself, it doesn't necessarily mean you should abstain from the continuance of your involvement in the case.
What does recusing mean?
Okay? That's what
Hang
I'm saying.
on, Palgrave.
Francis. No,
Palgrave. Abstain from the case, recusing. Please show me where the difference is.
You mean they are the same?
I'm asking you. Show me the difference.
No, you mean they are the same?
You're saying abstaining from a case
Yes.
and recusing
Yes.
are not the same?
No, Francis. You see, legal terms, I'm flanked by two lawyers.
Exactly.
You are going to go to the English dictionary.
But he actually said that he should stay
You
away.
should stand aside.
Stay away from the case. You should stay away entirely. That's what it means.
No, I think that the presence of and the presence of not of the AG does not determine where the case will go, because the case will be finally determined based on the facts that have been placed by the final judgment that will be given. I'm interested to see how far this case will go.
Should the AG take the advice of the judge to recuse?
The
Or
AG
to stay away?
The AG has an honest responsibility to the Ghanaian people. Took an oath, was vetted by Parliament. He needs to execute that responsibility. I would continue to. I think that the advice is in context of the secret tapes. And I think that that's the advice in context. And so if the AG would take the advice, it will be in the context of his understanding of how the judge has made the statement of recusing yourself. You understand? But it does not mean, which is why I said, I mean, I know you wanted to go onto your phone, which is why I said that it does not necessarily mean that you should stay away entirely from the process. Maybe further conversation. As I mean, I the tape I saw it was flying all around on social media.
You listened to it. I know you did.
Yeah, it's flying all around. You understand? So sometimes it becomes very difficult. But I would say that he has an honest responsibility that has been given to him by the state to prosecute.
You know, I'll ask you that question. So let me ask now.
Yes.
If you were the age, would you recuse?
No, I would not.
You stay on.
I'll stay on.
Like he has decided to.
Yes, I'll stay on because you see, I have a responsibility. That's why I said I have a civic responsibility to the Ghanaian people. I've taken an oath. I've been given an opportunity to become the Minister for Justice, and to ensure that justice is served to whoever.
And the very one you are going for justice from, things that you have basis to recuse.
No. I think that justice must be served, and
Regardless of who serves it.
Oh no! You see, it's the state. The AG is there representing the state and the interest of the state.
And it's an office. Other people could do.
Of course, it's
could
an
take
office.
it up.
Yes,
Yeah.
other people could take it up. Which is why I'm saying that he has that responsibility to continue to stay on the case. But the advice is in context. Obviously, it's in context of the tape. That's why I said. So if he continues to stay on the case, we hope that no more tapes will come.
Oh, that's your prayer.
Yes.
And if there are more tapes?
I don't think there would be any more tapes.
Oh, they are already giving.
There are indications that there's
permission
more.
for more tips.
Well, he should still stay on the case.
For all the tapes to be played.
Well, if the judge would have received those tapes in secret and listened to it.
In secret?
Or yes, I mean, if he
No, it could be
if,
found.
if it's been found, but if it's not found, I mean, then he would listen to it like it happened in this season as well. I would state that the Attorney General has a responsibility. And
Tape or no tape?
tape or no tape, the Attorney General has a responsibility to stay on, to make sure that justice is served. And really, you see, the consistency of the opposition to go ahead and state that the government or the Attorney General wants to ensure that Atoforsen is jailed, I don't think it's neither here nor there, because we haven't gotten there yet. You didn't even want me to go into the merits of the issues.
Because you shouldn't.
Exactly. So neither
In
should,
respecting the court.
of course, I
Yes.
respect the courts. In fact, I even fear the courts. You know, neither should the NDC. The NDC should not go into it to state that it is the intention of the Attorney General to make sure that the minority leader or the former Deputy Minister for Finance goes to jail. That's
Okay.
not it.
That's fair.
The main thing is to ensure that justice is served. And we all see the real evidence of the matter that is being tried.
Mr. Jantua,
Yes, sir.
your thoughts on the decision of the courts and also the advice to the Attorney General.
Good morning to our viewers. Good morning to my fellow panelists. First, let me start to ask. In terms of there being a mistrial, there doesn't seem to be any legislation in our laws where that is concerned. But, Counsel,
Yes.
can we not have a mistrial in this country with jury trials? We can.
Yes.
Yes.
Yes, we can.
Yes, we can. So it isn't that we don't have it at all. Because if this was a jury trial, they could indicate
Yes.
that based on A, B, C, D, E.
Yes,
Recommend
but
to
that
be
one,
on
because they
trial.
would say there's a hang jury.
Yes, yes.
Yeah,
yes.
which even we are not applying very well,
Well, this
because
is not a
when there's
jury
a
trial.
hang jury,
This is not a jury trial.
yes, I know, but when there's a hang jury, because people have been making, when there's a hang jury, the state has lost.
Yes.
It's as simple
yes.
as
But
that.
Don't let
But
us don't let us go deep. I just
is-
want
it is only here
I
that-
just want to establish
Yes.
that it isn't that we do not have it at all.
yeah, okay, I
Because
understand
it's
the
not
point
it's
you're
not
making.
a jury.
Okay.
Number two, there are two sides to this particular case in terms of the judge's direction. The first side is the individual Godfrey Dame. The second side is the Attorney General's office. And when you look at what she is saying, she is indicating that she suggests that the Attorney General recuses himself for the integrity
Of the
of
court.
the
In council,
Attorney General's.
but let me just chip in this information because I was in court. I didn't say it. And you see, the judge was surprised that Attorney General is not going to stay away or recuse because, you see, after reading the ruling, and then she now said that we should do further case management and then we should start the case again. And the Attorney General rose to begin to make submission. The judge asked him, does that mean you are not taking my advice? In court, the judge asked him right there. So it means that the judge.
And then what did he say?
I didn't listen carefully but
Okay.
yes, but the judge asked him. Those who were in court would attest to this. So it means that the judge was so surprised.
Okay.
That's just by the way, senior.
If she did say that, then it goes to show that her ruling really was not for the public to lose confidence in the Attorney General's office. Because definitely, if this went against the Attorney General, there will be a lot of question marks. Any case the Attorney General was prosecuting. He, as an individual. Now, for me, she was saving the sanctity of the Attorney General's department. Now, when you come to the details of it, and I would like Ghanaians, as much as possible, to get the case detail that was put before the court and read it.
As in the application that was made for the mistrial?
No, the case itself.
Yes. The ambulance trial.
Yeah, the ambulance trial, the case itself, and what was put to court to accuse the three.
Yes.
Ghanaians, go and read it. The case is already in court, so I would not want to say anything about what I've read and the way I understand what has been put out there. But go and read it and decide for yourself. Decide for yourself, because it will be a shame if this case, after it's heard and the verdict that comes out is either for or against, without you understanding
The base.
the base of it. When I got the case and I read it, I will not tell you what I thought, but let's leave it there. Now, when you look at
But Mr. Janso, why would you tell us to go and read something? And after you say what I think you will not share?
no, because I want you to make your own mind. I don't want my thoughts to mar anybody's
Perspective on the
perspective
matter. Okay.
on the matter.
That's fine.
Yes. Probably once the case is
Concluded.
concluded,
Senior,
then
it's
Able
not
to share.
everybody who will get a chance to read it. So
Oh,
tell
but-
them.
Oh, we'll
Now
get it.
listeners are interested.
No, well, there's actually a segment we have here every morning we do on court today. So we can take that up to share the
I
details.
have got the what you call it,
Yeah.
the
The document.
the document.
Yeah.
So it's,
sad.
it's acceptable. I mean, it's accessible. You can get it. Now, let me read what was said on Graphic Online with regards to what the High Court judge indicated. She said, and I quote, "The High Court judge overseeing the case had recommended that the Attorney General recuse himself after expressing concerns about Dame's interaction with Japa, the third accused, outside the courtroom." Is that not interference? Is that not interference in the case? And if there is interference in the case, how can the Attorney General indicate that people were setting traps for him? He fell into the trap. What the Attorney General did not do initially, and which he should have done, he should have considered the background of Japa. Japa is a security guy. He's a security guy. I've known him for quite some time. He works in the security. He's a security guy. And if he had considered the background of Japa, there were conversations he wouldn't have had with him. Because in the tape, what did we hear? What did he say? I hope this conversation is not being recorded. We heard it. didn't we?
Yes.
And this case has been going on since 2021, 2022. Japa, initially in the early days, could read where the Attorney General was heading for. So in order for him to be able to have evidence of interference, he recorded everything. And unfortunately, the Attorney General fell into the trap. Because really, the judge did not say you were trapped. The judge did not say there was no conversation between you and the guy. The judge noted that Dame had discussed case details with Japa and encouraged him to submit a medical excuse to facilitate an adjournment. Huge interference. A situation that an attorney general shouldn't be seen to do. And if for nothing at all, if the attorney general really wanted to get some information out of the accused outside, the first question she should have asked him, who is your lawyer? I would like to speak with your lawyer, and communicated with his lawyer. That didn't happen. And probably didn't happen because there was familiarity between the two. And that was taken for granted with regards to the way the Attorney General, now, when he asked to meet him, decided to take him to a location, a Supreme Court judge's house, which now draws the Supreme Court judge in. We weren't there, whether the Supreme Court judge was part of the discussions or not. But the mere fact that it was done in the house of a Supreme Court judge, the perception would be the Supreme Court judge was part and parcel of it. But from my information, the Supreme Court judge wasn't there. Whether after there was a discussion between the Supreme Court judge and Japa, or Supreme Court judge and the Attorney General, because he knows both of them. One is his good friend, one is his relative. Whether after there was a discussion, that one we don't know. But from what I know, it was intimated that the Attorney General is here, go have your discussion with him. And he went somewhere else, from what I understand. Now, if the Supreme Court, the judge is saying, I would suggest to you to recuse yourself. She's saying it for a particular reason.
Her exact quote is, it is my considered view that it will be prudent to strongly advise the Attorney General not to be directly involved in the conduct of this case. This is one way of ensuring that the judicial process is protected, and to gain public confidence and not give a perception that cases can be held at any other place except the courtroom. Those are her words.
Please, read that first bit again.
It is my considered view that it will be prudent
One, prudent, yes.
to strongly advise
Strongly,
the Attorney General
yes.
not
Not
to be directly involved
directly
in the conduct
conduct
of this case.
She apparently listened to the tape 10 times.
Hey, lawyer, how did you know?
That is what we were told. Or,
Yes.
Yeah.
yes, listen to the tape
Yes,
10,
that's what she said. She said it.
10
She
times.
said she listened to it about them.
Why would she listen to the tape 10 times if she didn't see that there was some untoward interference between the third accused and the Attorney General? Why? And she says, I'm strong. When a judge tells you in court, I'm strongly suggesting to you. Wakawasem, wubube.
What is the meaning of the be?
What's the meaning of the be? That down the road, from my little understanding, in as much as it has not been admissible, it can affect the results of the case. So, let's see where we go from here. Because you know something? If I were the Attorney General, I would not have even stood outside to have any interaction with any pressman.
And even sing.
I would not even sing to anything, because the judge had indicated that the Attorney General recused himself after expressing concerns about Dami's interaction with Japa. She had said it. So, if for nothing at all, you've been indicted on that particular bit there. So, don't say naught about it. Don't have any interaction with any journalist whatsoever. Now, mark my words. Japa is still under cross-examination. The Attorney General's office has not cross-examined him yet. If the Attorney General still decides to conduct that cross-examination himself, things will fly. Things will fly.
I suspect he's going to run away.
Well, I just hope he doesn't. I just hope he leaves it to his deputy to handle. Because Japa will see, it's my life, I need to protect myself. Attorney General too will feel, I've been exonerated and I need to push this guy as far as I can. And you will see the exposures that can come out. Unfortunately, there has been close statements made, haven't there? The lawyer for Japa, he hasn't made his close statement yet.
No, as yet.
But the first accused,
yes,
has. The Attorney General hasn't.
No.
Okay. So one has, two haven't. I would plead with my good Santa Clausian.
Godfrey Dame.
Yes, he's my disco boy. I will plead with my yes, like you are. I will plead with my good Santa Clausian to have a second thought on it. Look, there are quite a number of things Godfrey Dame has done that chalk his name up in terms of some of the things he's done to save the country of huge debts and all that, that they tell us. Don't allow this to taint you.
It's been tainted already.
Don't allow, according to the court, I'm going according to the court. For public opinion, it's public opinion. I'm going to according to what the court has said. The judge said that the evidence brought for these applications is not enough, I'm paraphrasing, to stop the trial. Yes? So I beg of him, he should leave that cross-examination to his deputy to do, or to the Attorney General's office to do, not him. Not him. Because Japa is not a small cat to deal with. If he could record you, and that was a P2P recording, there was no third-party recording in that conversation they had. He didn't even realize that he was recording P2P, person to person. And that should tell you the dexterity of Japa and his intelligence with security. So the president, members of the Attorney General's office, other influential members in the MPP, please, I beg, advise the Attorney General not to take on that cross-examination. I'll eat humble pie if that cross-examination is done and it goes smoothly and there are no misgivings or anything. But because if you listen, and I'm sure you listened to Japa's interview before they went into court,
Yes.
and you heard what he said, it's not going to be easy. It will not be easy. And if the Attorney General decides to do it himself, then he should make sure that whatever he is going to ask and he's going to say is watertight, that Japa will have no ifs or buts in how he answers questions put to him.
Okay, Councillor.
Okay.
Quick.
Because of time.
Just 2 seconds. Councillor, if the essence of your advice to the Attorney General to stay away is just to help him, then I would rather prefer that he does the cross-examination so that we can see the showdown with Mr. Japa. So, yes, because he should be exposed. He should be clearly exposed. But I suspect that he's going to run away. He's not going to cross-examine Japa. And then, under the pretext that, I've been advised by the judge not to be directly involved.
But
That's
he can
what he's going to
elect,
do.
he can also elect that he
Yes,
doesn't do
somebody
the
else to do
cross-examination,
it.
yes.
Yes, but clearly that would
He
mean
can,
if he's still
but
the
so far he hasn't shown that that is what he's going to do.
if he's still the lead prosecutor and he sits in court but allows somebody else to do the cross-examination, then the meaning will be clear. Everybody will know that he's running away from Japan. That's all.
No, but you know, Francis, I think that we should commend the judge for an excellent work done. Because I have always had faith in the judiciary, but other times you would hear the opposition say things about the judiciary that goes untoward. So I would commend the judge for being very astute in her work and bringing this judgment out. It's very clear that we have a future in this country, and that justice. Why are you looking at me that way, Francis?
Really?
You're looking at me like.
Wow, Bagre. I'm surprised with what you are saying.
No, but the judge.
The kind of appointment your president has made, we have no future
Eric,
if we are going to have presidents like that.
Eric, no.
Clearly, in the
You see,
judiciary,
I don't want to go into.
he's the
I
only
don't
one
want
that
to
has
go into-
impugned
I
the
don't want to go
integrity of the.
into things
He
that
has destroyed
Dramani
the.
Mahama has
No,
done.
he has
No,
destroyed the
let's not
judiciary.
go
Your
there.
president has destroyed
Okay,
the
so
judiciary.
let's move on to other matters.
No, I have.
And so,
one or
Francis,
two-
I
let me finish.
comment.
One or two comments to add.
I commend the judge for
The ruling.
Maybe
Okay.
so, there are judges who are so worried about the kind of appointment this president is making to the court. He's destroyed the judiciary. Some are really very worried. So I don't see the future if we are going to have
Francis.
president who behave this way.
Francis, let me ask the question. Why is the Attorney General and some Supreme Court judges in the face of the public? Why?
What does that mean exactly?
When you go to other jurisdictions, you don't even know who Supreme Court judges are. Attorney General hardly speaks. Hardly. I know best the UK. You hardly hear the Attorney General speak in the public.
Is this an unwritten rule that they are not in the public eye?
They are not in the public eye.
Why? Why should they not be?
They are not that. Their office does not entertain that kind of thing.
Why? They're serving the public.
They're serving the public, but the way they serve the public is not like any other lawyer serves the public. How many times have you heard the British Attorney General speak? Tell me. If there is a case, they handle it and they advise. But in this country, Attorney General is everywhere.
Is it just
Is
this
it
one
because-
or all the ones in the past?
Oh, well, generally.
Yes.
But this one is more out there.
Is it because he's much younger?
No. It's got nothing to do with that. it's got to do with the fact that we are not decoupling the Ministry of Justice away from the Attorney General's office. The Ministry of Justice is a political appointment, isn't it? Huh?
Yes.
And what do they do? The Ministry of Justice has got to do with human rights, all that kind of thing. And so sometimes he is pushed into the political arena. Attorney generals aren't people who speak that often. They are the Supreme Court judges and Attorney General are the bastions of cementing unity in a country, because that is the last place anybody can go to for redress. And so you don't have to be talking in public every time.
So they should stop talking.
I believe
Have a spokesperson. Have a statement here.
Whatever the case is, the sanctity of that office is such that, they are what? The rulers of the law.
Should the same apply to the special prosecutor?
The special prosecutor has a specific job. And let me ask again, my second point I was going to make. What is the premise of this case? What's the premise of this case? The premise of this case is what? Causing financial loss to the state. Bringing, and if I can use the word, unwholesome ambulances that nothing can be done with them. And some, my brother here called it trotro. President Akufo-Addo, Ken Ofori-Atta, have they not caused financial loss to the state? Have they not? Cathedral, how much money has been sunk there? Have you seen a pillar? Has it been able to serve us, the National Cathedral that they were building? How much of taxpayers' money was put in there? $58 million.
Are you suggesting to me today?
Let me finish. Don't put words in my mouth.
Have I put words?
Let me finish. When I finish, you ask me questions. Are we going to wait for a new government to come in place to look at that? Is there no cause of financial loss where the cathedral is concerned? Have we got results from it? And do you not think is the Attorney General's responsibility on behalf of Ghanaians? The Attorney General is there not only to advise the President, but the Attorney General is there because of Ghanaians. Are you telling me that the Attorney General cannot make a case for causing financial loss to the state where the cathedral is concerned?
And sue who?
Is that what you sue those who were propagating it?
The president, the finance minister.
Why not? Why is that impossible? Is that impossible?
Has it ever happened in our history?
The fact that it hasn't happened doesn't mean it can't happen.
Should it happen now?
It should. Is that not causing financial loss?
So Godfrey Damage should sue President Akufo-Addo.
You are asking me a question.
And Ken Ofori-Atta for financial loss related to the National Cathedral.
Wait. You are asking me a question.
Yes.
Answer my question. Has that not caused financial loss?
Evidently, yes.
Shouldn't it be tried? The same way we are trying this ambulance case. The same ambulance case is causing financial loss. No be so? Who started the cathedral?
The president.
Who brought it up?
Yes.
What did they tell us? Government money is not going to be part and parcel of it. Did they not say that? We realize that government money is part and parcel of it. Have we seen anything done there? Have Ghanaians got the use of the National Cathedral?
But is it practical that the president's chief legal advisor sues him?
I'm telling you that
for causing financial loss.
that the Attorney General is there for Ghanaians, not only the president.
But you have just said that he wears two hats.
And if the Attorney General realizes that there has been a misrepresentation by the president and the finance minister where Ghanaian finances are concerned and it's caused financial loss, he should be able to trigger it. Should be able to trigger it. Let's test it. Before were we taking, what do you call it, to court? Election, what do you call it, to court?
Petition.
Petition, we took it to court. We tested it, didn't we? There are so many things we've tested in this. Let's test it. Let's test it. Somebody will say the president is immune to it. He could be immune to it, but let's test it.
Senior, you see, we are making it even complicated. There are many cases, many instances in this government that Attorney General can prosecute without touching the president. The SML deal is there, PDS, they are all there. Yeah, so clearly there may be difficulty for Attorney General going to sue the president. I'm not sure, but we are making it complicated. I think the point he wants to make clearly is that Attorney General...
No, make your point. He has made his point. Make your point.
No, it's my senior.
No, make your point.
No, so the point is that the Attorney General
It helps in our judicial.
It's going
process.
after only opponents of his government. That is it. That is a problem. That's what we are complaining about.
Okay,
and
time.
no,
because of time. Guys, we've done only one issue this morning.
Yeah.
And I
It's an
know
important issue.
it's a big issue. Fair.
Do you know that, let me just add this, do you know that the law of causing financial loss, and it's very important for your listeners to know, there's no requirement, there's no element in that law that whoever is charged must have benefited from the conduct that caused the loss. So it means that you can be charged when it cannot even be proven that you even benefited one cedi from the whole deal.
Transaction, okay.
Yeah, it's only your conduct. So in that case, wouldn't Ghanaians be more interested in the money, in retrieving the money than getting people in jail?
Okay.
When Big C was prepared to give you back your money, that the money the government paid me, take it. Attorney General, come and take the money. Just give it
That's
back.
why I say.
He says no.
That's why I say read the case.
Yes, he says no. I don't want the money for Ghanaians. I rather want to put Atufosin in jail.
Okay. All right. Last matter for discussion this morning will be on a poll that came out this week from the lecturer at the Kumasi Technical University that puts NDC as the most popular party, but puts Dr. Bawumia ahead in the presidential elections as of today. Eric, let me start with you.
Well, again,
Briefly,
yeah,
3 minutes each so we can wrap it up.
Yeah,
I'm
yeah.
actually past my runway.
Yes, really, I don't even have much to say about this poll because it doesn't make much sense to me at all. Because the poll didn't say that they questioned respondents on parliamentary candidates and the presidential candidate. It's just NDC. So if you are, and NDC is represented by, so clearly to be presidential. So if you question people and they say NDC is more popular, then how did, so the question, we didn't even know the methodology, the questions were not put forth. So how could the NDC be more popular and yet the candidate of MPP will be more popular than the candidate of the NDC when the argument is not that, oh, okay, NDC is going to win more seats in parliament and perhaps lose the presidential election. They didn't say that. So clearly, I think it's just red herring, just confusing people. You know, you throw this in there just to shore up the maybe some publicity work for Dr. Bawumia. Otherwise, it doesn't make sense because the two are representing their parties. So if one party is more popular, then clearly that ticket is more popular than the other one. So that's all I would say about this. So this poll, I would not take it too seriously. Although it provides information, and every serious party, when you get information like that, you have to go
Look into it.
Yeah.
Okay. Palgrave?
Francis, you know, when it doesn't go well for the NDC, they say that methodology that was used was wrong. When
You
it goes
attacked-
well for them,
You also attacked
they say that methodology is
this
good.
guy, info
Analytics.
So, is he just confirming that if analytics is?
I say you attack them, so don't make the argument. That one, because
So when it goes well for them, methodology is good. If it doesn't go well for them, methodology
I think it's the same for both parties, isn't
yeah,
it?
that's what I'm telling you. That's what I'm reminding him.
For me, you see, Francis, I think the survey is clear, and there's not even a need for a survey because Alhaji Dr. Mahmoud Bawumia has been on a campaign which began the last week of April, and he's been engaging stakeholders, sharing his policies, and so I'm not surprised that a survey conducted now would put him ahead of the NDC candidates. But I know that Ghanaians are going to make a decision on the 7th of December. My hope and prayer really is that that decision will reflect surveys, especially in the good interest of the New Patriotic Party, the party that I belong to. for a number of reasons. Francis, I think we've gotten to an age where the next few years, you and I are going to be 50 in the next few years. And when you are 50, you'll be 85. You'll be 85.
And still looking 50.
Yes. We can't toy with our future. I've seen the candidates that have been presented for this year's election, hoping that no other new person will spring up anymore. I think that the competitive advantage is for the New Patriotic Party. Yes.
The CPP hasn't.
CPP hasn't.
Yeah.
But that's the incoming.
Please, I beg you. I haven't said anything to you.
Incoming
Yeah, my
flag bearer of
brother, but I
CPP.
haven't said anything to you, please.
I hope and
President Jantua.
No,
Okay.
that would be a nice flag bearer name.
Flag bearer name.
Flag bearer name.
Whether you win is another thing.
Yes. But to state it that I think that the Ghanaian people deserve better. And they deserve better in the leadership of Alhaji Dr. Mahmoud Bawumia. I don't know what Dramani Mahama can bring again onto the table. Because beyond the policies that we are hearing from the New Patriotic Party, there's not been a counter idea that we are seeing from the NDC. It appears as though they just want to come to power, the will to come into power,
Really?
and the will to come and govern. But we have a plan for this country, and that plan is going to be executed very well. And I'm sure that everyone around this table would vote on the 7th of December for Alhaji Dr. Mahmoud Bawumia.
Mr. Jantua.
Has your previous plan, let me take it from where
Okay.
Margaret left off. Has your previous plan worked for the country today?
As in the existing plan.
Yes, that should be the basis under which we determine both sides. And for me, this particular poll is neither here nor there. When you start a 200-meter race, what happens? Somebody in lane 1 will start the curve quickly. By the time he gets to the 100-meter mark, somebody in lane 6 has taken over. By the time they get to the line, nearly all of them could be on that line, crossing it. So for me, it's neither here nor there. Agroniform. Let's see how the people of Ghana see the leading candidates who have put their names forward. The good thing is that there has been a vice president in 2 of them. There has been a president in 1 of them. And there has been a vice president who has been part of decision making with the sitting president. This thing about Dr. Bawumia said, I've never been president before, so give me the steer, does not mean he hasn't been in the center to make decisions for the country. So let's see. It's up to Ghanaians to decide on the 7th of December who they would want. Be it MPP, be it NDC, be it when the CPP brings theirs out, when the PNC brings theirs out, and be it the independent candidate. Why are you pointing at me? Why are you pointing at me? And be it the
incoming
I'm not
CPP
incoming,
flag bearer.
please. And
Kwame Jantua.
and be
Flag
it-
bearer of the
no,
CPP.
I'm not the flag bearer of the CPP.
You have to be.
I'm not.
You have
I'm
to
not.
be.
And let me finish my submission.
When
And
is your
be-
Congress?
And be it the independent candidates who have also put their name forward. This election is going to be very, very, very interesting.
Okay.
Both presidential and parliamentary. The only thing I pray for is that we have a peaceful election. But it will be interesting.
The Electoral Commission must
and
be fair.
it will chalk a certain prominence for the country if we are able to go through with it
Successfully.
Yes.
Mr. Jantua, thank you. Pargev, thank you. Eric, thank you for your time. That should do it for us this week and today here on the Morning Star. Mid-morning goodness on the zone is up next with Natalia and Master J. Have a lovely day, people. Cheers. I'm out of here.